It is great to have you back here at Coin Lady channel. The legal dispute between the SEC and Coinbase was the subject of a 5-hour session. And this was about the possibility, or lack thereof, of having the entire lawsuit dismissed. Although I cannot say with certainty whether this will take place, I will provide you with the viewpoints of other attorneys, including attorney Jeremy Hogan. In this situation in particular, I'll tell you what his most recent legal prognosis is. Warning, this is a spoiler notice. The SEC is completely screwing themselves, and seeing the judge today, it was delightful, was anything but joyful. It appears like that. If you went back a year, you'd see Kim Jong-unza frequently boasting while appearing on national television. For example, we'd glance at the SEC record and say, "Look at me, I'm perfect." It's just that amusing. The rules are actually quite straightforward. Therefore, it stands to reason that we will prevail when we sue XYZ Corporation. Time has passed since then, because of all the lawsuits that have come out of it recently, from the SEC versus Ripple case to the Grayscale lawsuit. The SEC has had a terrible year, and you won't hear him mentioning that anymore. It doesn't matter how things were explained in the SEC v Coinbase case last year either. Litigation, which is the subject of our investigation here. The whole process has been a total fiasco, and judges aren't buying the SEC's bullshit. How delightful. The events surrounding the SEC v Ripple case, in my opinion, essentially established the standard. Just so we're clear, I don't come from a financial family or anything. Please do not base your investment decisions on anything I say because I am not a financial advisor. Creating films on YouTube regarding cryptocurrency is something I like doing for fun. I'm just an enthusiast. Okay, the Cointelegraph headline is here. Among Coinbase stances on Terra, Labs, and Howie are stocks. U.S. District Judge Catherine Polk-Fila has heard arguments from Coinbase and the Securities and Exchange Commission in their respective 5-day SEC face-offs. The exchanges are attempting to have the regulator's June 2022 lawsuit dismissed. Therefore, everyone, I must confess that I am unsure of the most probable outcome here. This is merely a YouTube character, I do not practice law. On the other hand, I've come to the conclusion that, after hearing the arguments of many crypto attorneys, the Judge Filer, might easily dismiss the case. For Coinbase, that would be a huge victory. I got it, maybe it will stay in the trash. Even if it doesn't work perfectly everywhere, it will still be a catastrophe in the end. Overall, though, I still think Coinbase will have a very bad time of it because they have a history of being in the wrong. We kindly request that it proceed. Over the course of its nearly 5-hour duration, the hearing gave a comprehensive synopsis of the main points raised in court cases concerning assets in the cryptocurrency area and the SEC's responsibility to regulate the sector. Judge Fila questioned the SEC lawyers to clarify how a digital token issuance would satisfy the Howey test, stating that the regulator's position was overly broad, and conducting a critical examination of the crypto exchange's evidence throughout the session. According to the SEC, there is a value proposition for token purchases, because token buyers are also investing in the underlying network or ecosystem. But Coinbase lawyers pushed back, saying that Bitcoin, which an SEC lawyer characterized as a commodity at the hearing, also has a community and a network. Judge Fila probed into what staking is and secondary market transactions, as well as recent decisions involving crypto companies like Terraform Lance and Ripple. So, have a look at this. I have some thoughts to share with you, and I think we can begin with this. From the mouth of attorney John Dean comes this remark. He relayed the viewpoint of attorney James Murphy, who goes by the name Meta Lawman on the social media site X. I will tell you what Murphy had to say shortly. Prior doing that, though, I should mention that lawyer Deaton relayed the words of lawyer Murphy and penned the following. Excellent synopsis. All of the pleadings, including the amicus briefs, are familiar to Judge Fila, who is treating this matter with the utmost seriousness. She is not, like most judges, simply denying the motion to dismiss. The breadth of the SEC idea is an issue that truly worries her. Furthermore, the theory's breadth. This isn't your run-of-the-mill dismissal, as I mentioned before. Regarding the case of SEC versus Coinbase, here is what Attorney Murphy had to say. The court made an uncommon move by skipping over the parties' prepared arguments and diving right into questioning their attorneys. For the first 2 hours, the lawyers for SEC were the only ones interrogated. The SEC attorneys had improved their preparation since the first pre-motion conference, which took place months earlier. Starting with staking, the inquiries moved on to his crypto applications, and finally to the major questions philosophically. The judge has a keen eye for detail and asked extremely specific questions that she had thought about beforehand. The judge stated that she was still considering all of the arguments and had not made a final decision. The judge made multiple allusions to the Coinbase amicus filings. She emphasized the importance of Senator Loomis's brief, which states that Congress must resolve the issues at hand, such as the classification of crypto assets and the ultimate regulatory power over Coinbase. The court is currently interrogating his attorneys. I anticipate that they will be here for at least a couple more hours. So, I'll just say it, I think the judge is being really fair. The SEC's attorney Assad believed they could get away with this ridiculous bullshit, and I don't think she's putting up with it. People were practically live tweeting this stuff, so I got a number of quotes from that. I guess it's in this one. For the simple reason that there was yet another instance whereby interested parties could remotely listen to the hearing, similar to the SEC versus Ripple case. As a result, many people were reporting events as they happened. Eleanor Turot, a journalist for Fox Business, made the following post. What follows is what she jotted down on X. I have no intention of live tweeting every word of the SEC v Coinbase hearing. On the other hand, Judge Fila starts off strong. She claims that the chief lawyer for the SEC and I, paraphrasing, the DeFi people, provided a quote in the amicus brief that explains staking and the wall's purpose possibly better. It's arguable that the quotation is more accurate than the Commission's briefing. Therefore, the amicus briefers did a greater job than the SEC in defining the SEC spaces right there at the gates. Very much so. Last but not least, she concludes her piece by stating that the SEC has failed to provide a counterargument about the legal basis of his position in its briefing. Yeah, that much is already known to us. We recently witnessed what happened in SEC versus Ripple, which was not good for the SEC. So, let's see how things unfold here, shall we? The arguments that the SEC has made thus far in various cases about how we tend to not go over very well. If this entire thing is tossed out, maybe we won't even have to make it. And we should find out about that in the next 2 weeks at the latest. After then, there was this article by Fox, a business writer, owner of TERT, and another SEC lawyer who works with exchanges. The post said, these 12 or 13 tokens are computer code. People are thinking about this, because, once again, the SEC has targeted numerous coins in this action, and they perceive the tactic as nothing more than a hindrance to the exchanges. Plus, you're starving, so you can't afford to take on any of the over 20,000 coin teams out there. You then go on to list the problematic coins transacted on this site, citing whatever BS explanations the asset attorneys may have come up with. In response, the SEC attorney reiterated that the 12 or 13 tokens in question are, in fact, computer code. Since she apologized, I figured we'll just interrupt and file the judge's report. But isn't that exactly what your Coinbase-referring friends at the back table are saying when they ask what we're up to here? The whole point of being here seems pointless if it's merely code and those fears. And that is why I am telling you this, guys, even if I am not going to make a dire forecast about whether or not this item is tossed out. They may even be stating it as the court rules. Then why are we even here? For what reason is this going ahead? Is that so? According to the SEC lawyer, yes, Your Honor, was the next thing stated. Judge Rakoff's decision in the Terra case upheld the idea that a token's ecosystem is what defines it as a security. The judge's file also cited Bill Hinman in support of the idea that a token is not a security on its own, as I will explain in a quote. It was Mr. Hinman who allegedly quoted an employee who is no longer with your company. In a word, yeah. Yes, it is true. Another update from Eleanor's turret. Judge Fila is requesting that Coinbase lawyer explain the reasoning behind the Terraform and Ripple decisions, which deal with investment contracts on the primary and secondary markets. She wants to know what aspects of these rulings can shed light on Coinbase's position. The lawyer's main point was that, although the two cases are very different, Terra's a Taurus, for example, the courts ultimately determined that a security must have an actual underlying contract or agreement between two parties in order to be considered a security. Yeah. For this reason, the SEC v. Ripple case sets a precedent for all further litigation involving cryptocurrency. Sure thing. When we got that letter, it was a huge deal, not just for us XRP holders, but for the entire space. For all the reasons I've already mentioned, XRP is my preferred cryptocurrency. I made that clear multiple times during that dispute. It's my biggest personal holding, and I have a prejudice for it. I have around 30 different cryptocurrencies, so if this one doesn't work out, I'm concerned about what will happen to the rest of my assets. It wasn't just about XRP for me, I was concerned about all the opportunities they would try to seize from my crypto-related life-changing money, even though XRP was obviously front and center. On top of that, you have this from Jeremy Hogan, an attorney, and you provide a photo of Judge Violet. No one, including myself, knows how Judge Philo will decide the Coinbase dismissal request. But I'm relieved that she has a firm grasp of the relevant legal and technological concepts. Coinbase is given a fair shake by that. In the grand scheme of things, it's all that matters. For the sake of argument, though, I'm going to speculate that she may dismiss part of the complaint, the staking allegations, for example, which have always appeared ridiculous to me, and send the other parts of the lawsuit into discovery, giving Coinbase a partial win. So there you have it, it appears that they believe the case will likely proceed. Perhaps not everything even tries, for example, this staking part is so blatantly foolish that it might not even be considered. In a subsequent article, he mentioned that we should expect to learn the fate of the situation about the actual dismissal within the next 2 weeks. As a result, we ought to have the answer soon. In any case, I really want this entire thing to be tossed out. However, we will see the outcome. Then there's this post from another XRP member. I believe it's fair that that's kind of spot on. The judge can't even comprehend what the SEC is saying, according to YouTuber Michaelia. Bill Morgan, an attorney, published the post and speculated that the judge may be perplexed by the SEC's lawyer's admission in her court that tokens are not securities, while the SEC chairman insists that the vast majority of tokens are securities. The SEC is unclear on its own. I understand, that was the most important thing to me. There are Kim Jong-un's claims that the tokens are securities, and you can see them all over national television with a ridiculous face hole. After that, you have these dweeb lawyers arguing in court that, well, it's just code. I am astounded. Oh, that's right. In theory, that's all. Next, we have this piece written by lawyer Bill Morgan. Everyone now knows that tokens are not securities in and of themselves. Judge Torres's ruling that XRP is not a security was supposedly just the beginning of the waves caused by the SEC's summary judgment, but it appears to have had far-reaching ramifications, including on the SEC's position. The crypto community is indebted to John Deaton, the Ripple legal team, and Ripple itself for everything they did in the SEC versus Ripple case. Yes, I agree with it. Have they learned anything from their devastating loss in the Ripple lawsuit? If so, would they be stating the same things in this case? Questionable. In the context of the cryptocurrency asset class it represents, John Deaton's representation of 75,000 XRP holders is, to put it mildly, revolutionary. There aren't enough words to describe how huge of an issue the SEC v. Ripple case is. It's the biggest, most important, consequential non-fraud case that has come up in decades. Seriously, it was that massive, and it's never happened before. XRP holders wanted to be named as defendants in a lawsuit so they could challenge the assets in question at the SEC. I am astounded. This is really unprecedented. 75,000 people raised their voices in a single second. You are cruising. Wow, that's spectacular. In this case, it has had an effect, I'm afraid. Furthermore, it has a positive effect on the SEC in comparison to Coinbase. Case. How this plays out will be determined by us. Overall, I don't think things will end well for the SEC. Those people are horrible beasts who have chosen to ignore history's lessons. Do not put your money where your mouth is. I am not a financial advisor. The standard request: hit that like button and subscribe. Goodbye for now.